Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I'm your host, Marianne Petrie. You can find me on dismantlingfamilycourtcorruption.com. You can find my books on Amazon that were published by Triumph Press: Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, Cry Out for Justice, Poems of Truth, Raised by These Wolves, How Family and Federal Courts Are Failing Our Children. And feel free to buy me a coffee to help keep this podcast going. And I have a return guest. I'm so happy to have on Jay Rosenthal back on from cpsprotect.com. He was last on the podcast, season 3, episode 87, and season 4, episode 73. Today, we're going to talk about Hogan versus Cherokee County and what happened in that case, as it was a custody and visitation agreement. And apparently, these aren't commonly used, or if at all. How are you, Jay? And how did all this happen?
I'm great. Marianne, when you brought me this case to review and potentially discuss, I thought, well, there are a million of these cases. Why this case? And I took a look, and this is a very interesting case. Um, Not necessarily precedent setting in a big way. It's going to affect most cases. It was fairly exceptional. But
Mhm.
that being said, it was very interesting and shed some light on a major disconnect between between CPS policy generally uh, and how and its execution. At
Mhm.
what point does CPS determine a child is safe, and how do they make that determination? It's relatively established that there is a lot of inconsistency, but this case gives a real window into how that inconsistency and how the terms that we use, uh, how those definitions, especially when they're vague, can really have profound consequences.
Right, because I'm hearing from a lot of parents that they're bothered by CPS or they're being retaliated on by CPS, and kids are taken away from fit parents. I don't want to go off track, so I'll let you keep going.
Mhm. Certainly. So this case centers around, as you said, a custody and visitation agreement. Uh, Essentially the plaintiff, the father, Brian Hogan. This is in North Carolina. He, his wife had gotten cancer, and it was pretty severe. He was spending a lot of time at the hospital. He's still trying to work, maintain an income, uh, the whole 9 yards. And so he had temporarily placed his children with his daughter. He had one child with a neighbor that he trusted.
Mm.
And that should be, under CPS rules, considered responsible. You're taking into account the time that you have, using collateral support
Mhm.
for supervision of your child. That should, uh, under most circumstances, it's standard practice to consider that protective.
Mhm.
Now, in this case, for whatever reason, they don't really go into the rationale for this. Uh, North Carolina DSS, essentially the caseworker and the supervisor, had determined that this was not adequate. And they had essentially, because CPS can do this, just like law enforcement can, well, they can't just go and blatantly lie to you about a document necessarily. They can use deception
Mhm.
and withhold certain pieces of information in the pursuit of uh, getting information to make sure the children are safe.
Mhm.
Whether we like it or not, that is the case. And that's no different between CPS and law enforcement. That is one thing they have in common. And what they pushed Mr. Hogan to do essentially was place the child with family. There has been a push in recent years to increase the use of kinship care rather than general foster care. And you could argue the neighbor was kinship, but placement with family may have played a role. However, his only family was really his father.
Mhm.
And his father was particularly abusive to him as a kid. They did not have a really great relationship. He expressed concerns about placing his daughter with her due to that history of and his experience. But North Carolina DSS was particularly insistent. And so they had, what North Carolina DSS basically demanded, pushed for,
Mhm.
was what's known as a custody and visitation agreement. And this is different. For those who have dealt with CPS before and had a placement, an out-of-home placement uh, outside of the jurisdiction of the court, they'll be familiar more with a VPA, a voluntary placement agreement,
Mhm.
where a family basically agrees in order to avoid court to voluntarily place the child or children with a
Mhm.
relative or a friend uh, temporarily for maybe 3 months, maybe 6 months, whatever it is, to address the safety concerns that CPS has. That doesn't necessarily always go well, and
Mhm.
CPS tends to nitpick, but in theory, not a bad way to avoid court if it's one of the minority of neglect cases that where there really are issues that can be resolved without bringing the court into it.
Mhm. Mhm.
Again, that's in theory. In practice, totally different deal. A cus you know During these voluntary placement agreements, what ends up happening is the case is still open. The caseworker is still making visits to assess the child and the family, make sure that they are addressing the safety concerns. That's best practice. I know it doesn't always happen, but in theory, that's the way it should go.
Mhm.
Now, in this particular case, they used a custody and visitation agreement, or a CVA.
Mhm.
And where this differs from a VPA is a custody and visitation agreement is essentially a permanent agreement. And what ended up happening, what Mr. Hogan signed in this CVA was basically a permanent placement where he had some visitation.
Oh.
Now, he was not aware of this. Uh, and DSS, although it was not a formal practice, uh, they were they were doing this a heck of a lot.
Mm.
And immediately after the CVA was signed and the child was placed with the father, the plaintiff's father.
Mhm.
The child's paternal grandfather. Uh, North Carolina DSS basically closed the case. They didn't basically close it. They closed it because in their minds, essentially, we placed the child with kinship. We did it permanently, and therefore the safety concerns have been addressed, so we don't need to be involved anymore. This was a big
Mhm.
mistake.
Oh yeah.
Mr. Hogan's daughter ended up um, being abused. She was deprived. I've heard much worse, but this was particularly nasty. Um, Mr. Hogan was berated. He was denied visitation. Now, eventually, uh, this was brought to court, and the court reunified. This was about a year later. Uh, his daughter, Brian Hogan's daughter, with him. And that was very good. Now, this resulted in a lawsuit. But before
Mhm.
we get into the lawsuit, I want to go back to the circumstances of the signing of the CVA, because this is very important.
Mhm.
I see a lot of parents talk about how their rights were violated or DSS lied to them and their case didn't work. So the question is, why was this successful where my case wasn't? Is a question that a lot of parents will ask. And one of the major reasons is, let's say CPS lies to you and blatantly lies to you, and let's say that you have an audio or video recording of it, or you have an email or text message record that is timestamped. Great. But that is open to interpretation in court. There's a very fine line between the deception that CPS and law enforcement can use and and blatantly lying with malicious intent,
Mhm.
especially because this lying is, especially in cases like this, uh, an intent violation. So if you can't, so proving intent is very difficult to do, especially in cases like this. But Mr. Hogan was actually illiterate.
Mhm.
And this is an important distinction because this is something measurable and really not open to interpretation. The government, for measuring adult competency in adult literacy, has essentially a 6 point scale, which goes from less than 1 to 5. So less than 1, 1, 2, 3, 4, and 5, with 5 being the highest competency in adult literacy, and less than 1 being the lowest, essentially as illiterate as you can get.
Mhm.
So that is something that is measurable by the government standards. It's not something that is easily, and it's not something that is easily disputable. On top of that, the DSS caseworker informed Mr. Hogan that this was temporary and he would get his daughter back. And so what happened was he couldn't possibly have been sufficiently informed because he couldn't read what he was signing. He didn't understand what he was signing, and he wasn't told what he was signing. And this is an area where DSS is required to be more transparent.
Mhm.
So in that sense, they in this lawsuit under Title 42, Section 1983 of the United States Code,
Mhm.
essentially deprivation of rights. They did use the 14th Amendment to basically, that was the bread and butter of this lawsuit. And there are, I've heard a lot of parents cite the 14th Amendment as their bread and butter as well. And this doesn't usually work
Mhm.
in my experience. But in this case, it did. What they usually cite is a very particular sentence in Section 1 of the 14th Amendment of the U.S. Constitution. And that reads, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws. Now, a lot of parents interpret that as parental rights are enshrined in the Constitution. I really have not. There might be an obscure case where that was interpreted that way. I have not personally seen a case where the 14th Amendment was interpreted in such a way. Maybe there is one, uh, but precedent for that is definitely not common. So, at the very least. In this case, because he was illiterate and he didn't understand what was going on, that was clearly a deprivation of rights because he had a right to be informed of what he was signing there. So what they did was it wasn't the lawsuit wasn't grounded in
Mhm.
his parental rights being violated. It was essentially grounded in him not being informed. And that's another really important distinction is if you're going about it asserting that your parental rights were violated without due process, that's very hard because due process doesn't have to be fair. It doesn't have to be moral. It just has to meet the minimum requirements for due process. And that's another important distinction. is something can be legal and completely immoral.
Mhm.
It, it brings to mind the saying, just because you can doesn't mean you should. Now, the government has a lot of trouble with that. Um, just because you can means you should. It seems to be the rule of thumb, because if you don't, you could get in more trouble.
Mhm.
It's unfortunate, but that does seem to be a general theme. Look, are there some good caseworkers here and there, some gems? Yes. But a lot of this has to do with the way things are structured, and in a field with an extraordinarily high turnover rate, those gems tend to leave even faster.
Mhm.
So if you do find one of those gems, um, get the case wrapped up ASAP, because they may not be there for long.
Right. Right.
Best advice I can give in that regard. So, moving on in this particular case, um, it, it, there was a 4-day trial here, and I've only talked about Brian Hogan as a plaintiff, but his daughter was as well. Um, the custody and visitation agreement was basically deemed unlawful, because they uh, here he wasn't sufficiently informed of it. There was no legal involvement, so it was essentially entered into voluntary.
Mhm.
There is a gray area there if you enter into a voluntary agreement, whether it has the force of law.
Mhm.
In this particular case, they ruled it didn't have the force of law, and my guess is it's because of the nature of its permanency.
Mhm.
If it was notarized, if it had gone it through some other sort of process, this might be a different story. But fortunately, it didn't, and this had a happier ending. When it comes to this case, there's also something else unique, and that is that one of the things that made this so successful is that this lawsuit occurred after dad and daughter were reunified, and successfully reunified at that.
Mhm.
The truth is, if your parental rights are terminated, and your appeal is essentially rejected, and I'll be honest, in most cases, the appeal falls flat on its face. Consider yourself lucky if it doesn't. Um,
Mhm.
uh, uh, the chances of winning the lottery are higher.
Uh-huh.
Um, so even if you have a case after TPR, what happens is, these cases usually take so long that by the time uh, they're actually adjudicated accordingly, what ends up happening is the rationale ends up being it's been potentially years at this point, and so disrupting the child again,
Mhm.
in theory, would be detrimental to the child. So what you end up getting is just a monetary settlement, and reunification doesn't actually happen.
Mhm.
That, in my experience, is extraordinarily rare. In the past 3 decades, I can, where the child is successfully adopted. When the child is lingering in foster care, that's a different story. But after a successful adoption, I've seen maybe 5 cases at the most in the
Mhm.
past 30 years, um, where that even happened, and it happened pretty quick. Um, so in this case, they essentially waited until dad and daughter were reunified to go after them. Because
Mhm.
when DSS has the upper hand, what ends up happening is, if you essentially go and uh, threaten them while they have the upper hand, it while it doesn't make them more likely to reunify faster if you're at least respectful.
Mhm.
Uh, it definitely could make them less likely to successfully reunify. And so, generally speaking, I tend to say wait until the case is over before you go and attack them with a lawsuit. Now, I know there are concerns about how do you put it? The
Retaliation.
statute of
Oh,
limitations.
yeah.
Uh,
Hmm.
but generally speaking, if you file that lawsuit at the same time, it's not really going to scare them.
Hmm.
It, and even if it does, it could hurt your case. Generally, that's my experience. If you go and do that at the same time, and I'm speaking from more from a policy perspective here, rather than a legal perspective, uh, if you do that, what I would say to that is, I hope you're right, because that's a hell of a gamble.
Oh, yeah.
And you might be, you might be, but the question is, how much are you willing to gamble here?
Hmm.
Uh, it, in my experience, one of the reasons that a lot of parents want to rush to this, and it's more important to be right as soon as possible than it is to win in the long run, is because especially if there is a removal or a placement or otherwise, these cases go on for a long time. And even if it's just an investigation, let's say it lasts less than 2 months and it's unsubstantiated, the trauma from that is still real.
Hmm.
So you can't really discount that. And let's assume reunification is happening in this hypothetical case that I'm describing. Well, by the time that's actually happened, most parents are just so exhausted from all of it
Hmm.
that do they really want to continue for another several years to a decade to hold the government accountable for what they did?
Hmm.
Usually the answer is no. They just want to move on with their life. They're just thankful that they're back. And there is this legitimate fear
Hmm.
that if they don't do both at the same time, that they'll never end up doing it. Um, and it's very much an emotional thing
Hmm.
that can have profound consequences. Again, if you decide to do it, I hope you're right. But in my experience, eh, that has an even lower success rate than waiting. But I would say that, like this lawsuit, the lawsuits that have the highest likelihood of success are post reunification. There are specific technical violations. A technicality is essentially a family's best friend, especially on, rather than law, actually on CPS policy and practice. A specific, well-defined technicality uh, that causes that causes harm to you and or your child is usually something that, when identified and there is a legitimate threat, can make CPS start to sweat a bit. Although, let's be honest, it's not their money that they're losing; it's
The
the
taxpayer.
taxpayers.
Right.
Um, so there's that problem too. As you know, if the agency loses money, well, they're just going to beg for more, and they're going to end up getting it, or taxes will be raised, or whatever.
Hmm.
So if you think you're really hurting them by a settlement, um, you're really not. Eh, Granted, that settlement can be particularly lucrative for you, but if it's not a precedent-setting case, it, it doesn't really hurt the agency.
Hmm.
Um, and that's also important to keep in mind. Um, Not that it's a bad thing to try and hold them accountable, but it is a selfish thing. And let's talk about it for what it is in that regard, unless it is particularly precedent setting.
Hmm.
So they did get compensatory damages in this particular case. And this was under Rule 59 of the Federal Rules of Civil Procedure. And for those who are unfamiliar, in addition to the statutes in the U.S. Code, the Constitution, the laws, etc., federal, state, municipal governments also have rules. And these rules are unique in their own right. So when you are looking at precedent or laws, that isn't always enough.
Mm.
And yes, it is very complicated, very annoying, very tedious to search. Hopefully, artificial intelligence will make that even easier as time goes on. It already is
Mhm.
improving that, although reliability is still concerning,
Mhm.
um, especially with what's potentially at stake. But anyway, back to Rule 59 of the Federal Rules of Civil Procedure, because this was really important. The court may set aside a verdict and grant a new trial. If the verdict is against the weight of evidence, is based upon evidence which is false, or will result in a miscarriage of justice, even though there may be substantial evidence which would prevent the direction of a verdict. And there are multiple precedent-setting cases that are cited in this particular review. So basically, actually, DSS basically asked for a new trial. In this, they were denied, and the damages were in the millions. This is this was a particularly egregious case. And let me correct myself. I realized that I said it was cancer at the beginning. It was a heart problem
Mm.
initially, not cancer, and I apologize for that. So essentially, uh, the one in terms of the remedies, other than the compensatory damages, essentially, DSS blamed it on poor training and clarification. When it comes to that, I almost want to call it a non-falsifiable argument because it gets used so much. And oh, we didn't include that in the training, and so that was missing. That we probably shouldn't do that. And uh, that makes me think, um, so do they have to read and basically memorize all the state and federal statutes, all the state and federal rules, all the local? Do they need to be the brightest legal scholars of our time? Is that what's sufficient? Because you're never going to be able to account for everything here. So it angers me because it's almost a catch-all. And then we'll go and revamp the training. And look, I'm a former CPS investigator myself. I will say I went through 60 days of initial training, and it was pretty intensive.
Mhm.
Then I got to the field, and I realized this is nothing like the training I received. This is absolutely nothing like the training I received. And I had to basically figure it out on my own.
Mm.
And I think a big problem with this is the people who design these trainings are so far removed from the front lines
Mhm.
that even if they were on the front lines 20, 30 years ago, they tend to forget what it was like actually being on the front lines.
Mhm.
And that makes it very difficult to know or to understand what somebody actually needs in the moment to do their job. Because you're, let's say you are one of the gems, okay? In theory,
Mhm.
if you've got so many cases that you actually don't have the time to to actually get to know a family
Mhm.
and their needs and actually address the safety concerns. And you're just looking to meet deadlines because that you're required to meet so you don't get cited and everything else. And you're anxious about that. And case after case comes in and crisis after crisis comes in. So there's never really any any time to breathe or really focus on a case. Every time you try and sit down and do paperwork, all of a sudden, here's another fire that you got to put out.
Mm.
And more often than not, they came at 4 o'clock in the afternoon, sometimes later. So yeah,
Mhm.
then dinner goes out the window,
Mhm.
um, pretty
Yeah.
quick, which usually happened at least once or twice a week.
Mhm.
Um, so at that point, you don't even have the time to actually address this, and that results in very sloppy casework. Now, I never, uh, yeah, I always did my due diligence. I always went by the book, but in other states and other caseworkers, there are legitimate cases where they're actually just not going and interviewing, and everything is lackluster.
Mhm.
Um, when it comes to actually knowing what's on the front lines, when I went and started CPS Protect Consulting Services, one of the first things I swore was that I would always, even if I cherry picked what I did,
Mhm.
no matter how successful it might have been, I would always take, at least one, not necessarily case, but with urgent assist, I'd meet with at least one subscriber per month, and like I'm, in a frontline capacity, uh, because if you don't really experience it for yourself routinely, you are guaranteed to fail
Mhm.
to understand the needs because you don't experience it. And there is something about being in the moment, being
Mhm.
in the trenches, that you can't get in a classroom, you can't get in a textbook, and you can't get from feedback. I remember we were, there are many, most industries have quality assurance or quality improvement.
Mhm.
I remember this case where the quality assurance team basically audited us. And in order to justify their existence, they had to find something that we either hadn't done or anything else. And it was the most frivolous thing, an archaic thing that wasn't even standard practice anymore because we'd basically done everything just to justify their existence. And
Mhm.
all they did was actually prolong the case, which was going to be closed as unsubstantiated, if I remember it correctly, uh, and it just took away time from the cases that really needed our attention.
Mhm.
And then on top of that, it delayed us closing those cases. So there's a compounding effect. A lot of families, when they get frustrated because, oh, a caseworker hasn't shown up, or why is it taking so long to close my case? This is pretty much done. Caseworker said they already figured it out. What the heck happened?
Mhm.
All this stuff in the background happened. uh, and then look, there are cases, plenty of them, where there actually is corruption,
Mhm.
and while it's not as common as people realize, because now it's just like with terms like racist or bigot or Nazi, when you use it basically too much, and to basically describe everyone you don't like or disagree with, what ends up happening is it loses its shock value, and nobody cares anymore. It doesn't hold the weight that it does,
Mhm.
and I think that we've done that with the term corruption, which has a much narrower definition. Uh, and I think it makes it harder
Mhm.
for the advocacy, uh, for the activist community in this space to be taken seriously. It, it, it's a way that, and this may be a hot take, but it's a way that they're essentially shooting themselves in the foot.
Mhm.
You need the people who don't have a vested interest in this to join you. And if what you say makes them look at you more like you're crazy rather than having a legitimate grievance, which many of these parents do have, it doesn't get us any closer
Mhm.
to fixing what I call the child welfare problem. So in a case like this, it's very good that there was reunification. It's very good, and but it is just one case. And
Hmm.
when it comes to corruption and legitimate issues like this, when I say that corruption isn't necessarily as common as we necessarily think, it's not because there aren't a lot of cases. On average, there are about 4.5 million reports to the child abuse hotlines every year in the United States. About 2.5 million of those are investigated, and they involve approximately 3 million children. Uh, Termination of parental rights rates, for example, vary by state, between 1 and 8%, but nationally the average is about 1%. But let's say you have over a period of time, if there are 89 million parents, right, in this country, which as of 2023, there were 89 million parents, and you assume that all of them are two-parent homes, and of course they're not all two-parent homes, but I'm trying to come up with a conservative estimate here.
Hmm.
That essentially gets it to about 45 million. 45 million parents with minor children. Okay.
Hmm.
And 1%, if more than 1 in 3 children, so let's say it's 1 in 3 children, because it's
Hmm.
about 37.4% will face a CPS case.
Hmm.
Um, so if we assume that it's 1/3, so about 33%, if 33% of 1 million is essentially 330,000, 330,000 times 45 million is, bear with me, I actually am not that good at math. I need to
Oh, I'm
do
not either.
this.
Don't feel bad.
Okay, 45. 45 million. Okay, I apologize.
That's
All
all
right, if I
right.
could only
No,
type
I
this,
suck at math.
uh, 45 million times 30.333. Okay, that's 14,985,000. Okay, and so 14,985,000, and this could be um, over a course of, let's say, 18 to 20 years, right? Um, so let's times that by 1%. That's 149,850. And if we take 149,850 and divide that by 20, we get 7,492.5 terminations of parental rights in a year. Now, this is not, this is just a rough estimate. I know from statistics, it's not actually. Actually, I forget if it is that. That might be reasonable. I wouldn't take that as gospel because I just did this off the top of my head, roughly. But if it's 7,492.5 terminations of parental rights, and let's talk about 1% of that, and this is per year times 0.01. That's about 75 cases. So if you have 75 cases of improper termination of parental rights every year, okay, over an 18-year period, that's 1,350 examples. And I'm probably underestimating this a bit. I'm probably underestimating it. And I just focused on termination of parental rights, not just not placement into foster care, not a substantiated case, not where there are other grievances. So even if you have, when you break down the numbers, even if it is 1%, you still have a lot of examples of this, and that number itself is higher. So it's possible that really the corruption, if it's 1% of terminations of parental rights, that that means that 99%, legally speaking, not necessarily morally speaking, but legally speaking, are considered legitimate. Now, there's an argument that the laws might not, be particularly just,
Mhm.
but here that's a discussion for the legislature, not for the judicial branch in that regard. And remember, they're using a combination of law and precedent. And there is good precedent and there is bad precedent. And if bad precedent is used to make an argument and it convinces a judge, well, you've got a bit of a problem. So here, the judge did side, and let's get back to this case. So here, Mr. Hogan did make efforts to really see his daughter, and he had to go to court to actually invalidate the CVA. And this actually, keep in mind the sequence of events here. First, North Carolina DSS got involved because a report was made by the school. Then they had concerns because the child was placed with a neighbor. And then the CVA was signed. About a year later, this was brought to court and to invalidate the CVA and reunify. And then the lawsuit was filed. And that sequence of events is very important because it had already been shown that there was something unjust, and the ruling that brought his daughter back to him and the invalidation of the CVA actually brought more to their arsenal. And what I hope that your viewers take away from this particular case is what makes it more likely that a lawsuit might be won. Truthfully, every second from the moment a CPS case is open matters. And in my experience, the smallest mistake you make, whether it's in court or outside of court, okay, before court involvement, after court involvement, or there's no court involvement at all, the smallest mistake can prolong your case by 3 months. And that's an average in my experience. 3 months is a long time. If you think in a CPS case time moves fast, it basically slows to it makes a sloth look like Jesse Owens.
Yeah.
Or at least that is the experience of most parents in my experience. Based on my interactions, both as a CPS investigator and as a child welfare consultant. So I think it's really important that we actually look at the experience. And this is what the court really doesn't care about. They care about the legal precedent, who makes the better argument. And he talks about how losing his daughter made him feel. And he says the following: they made me feel like I was worthless and I was no good, that I just didn't care about her, and I did with all my heart. My baby's my everything, and I tried to do everything the right way, everything they asked me to do. And I couldn't gain no ground. I couldn't get above water. Now, that is a real tearjerker, if there ever was one. And it may not have been the most eloquent testimony, but I know that almost every parent who's in a similar situation to Mr. Hogan has some feeling similar to that. There is a reason that termination of parental rights is often referred to as the death penalty of child welfare. So many mothers, so many fathers, they truly, so much of their life is invested in their identity as a mother, as a father, as a parent. Really, their kids are the most important thing in the world to them. Look, there are some exceptions where there are those who don't want to take responsibility, are much more self-centered. But let's assume a better world than this podcast usually paints for a minute,
Hmm.
and assume that there are more parents than not that do feel like Mr. Hogan and do really try to take the best care of their kids. Um, this was truly profound, and I don't think there's any amount of money
Hmm.
that could ever truly satisfy it. When your child isn't young forever,
Right.
and every year you lose is truly devastating because you can never get that back. Um, I I hear a lot of parents complain that, for example, the court takes so long. Uh,
Mm-hmm.
a lot of that has to do with just the bureaucracy of it all. And especially what's cited is even if there have been allegations that have already been dismissed, taken off the table in court, the attorneys tend to fight tooth and nail and cling to whatever is left.
Hmm. Hmm. To drag it out.
And yeah, it's taken me a while to really nail it down and nail down the problem. And it's not so much a legal or policy problem, it is a social problem.
Hmm.
And it, the reason for it is it, the legal and cop shows actually tend to get this right. It, when an attorney, for example, is applying for a job,
Hmm.
one of the major questions they're asked is, "What is your win percentage? What's your win rate?"
Hmm.
And the higher your win rate, obviously, the better you look.
Hmm.
And if you are measured as an attorney and you're paid to win your cases, that's what you get your salary for, then you have to, then all you're doing is your job. And there is an argument that, one should be, at least morally speaking, seeking justice. But here, this is how they are viewed. This is what they are supposed to do. And in law school, most law schools don't even have a single class dedicated to child welfare law.
Hmm.
I've yet to come across a law school that actually does. So anybody who has an interest in it really has to go uh, outside uh, outside the classroom, outside the internships available, and really seek out that information and those experiences for themselves. So there is a lot of ignorance when it comes to child welfare law. Uh,
Hmm.
the but here, if you want to really have more of a focus on justice, you want to really have a more moral approach to it. It's not you can't legislate that out
Hmm.
of you can't legislate that transition. It has to be a social transition. And in order to do that, the legal profession has to find another metric to rely on. Because otherwise, this is what's going to continue happening. It's not that it necessarily that an attorney is looking to make someone's life miserable.
Hmm.
They're literally trained to be to do whatever it takes to win, and if they don't, they essentially lose value. So, look, you could argue that you only care about yourself, you only care about money. Well, we should care, A, about our own survival, and B, I've never seen a parent care more about somebody else's kids than their own.
Hmm. Hmm.
And there's a reason for that. You should care more about your kids than you care about somebody else's kids. They're
Hmm.
your offspring. They're your kids, and they don't rely on so. nobody else is gonna do as much for them as you are as their parent. So therefore, you should prioritize them over other kids, and that's what parents do.
Hmm.
And it, it's when you make this comparison, you start to see, even if you believe one is more important than the other, you
Hmm.
start to see the problem in a slightly more compassionate light. But this is why a lot of these precedent-setting lawsuits aren't particularly effective. I mean, part of it is, yes, there are nonprofit foundations that are basically, you know, behind every commissioner appointment,
Hmm.
the laws that are pushed, the whole nine yards. It's the top of the child welfare food chain, essentially. But I think there's a bigger social problem, and generally speaking. Uh, and you can't legislate that away. A lot of parents seem to think that legislation is the solution.
Mm-mm.
But if government is the solution, I think we're desperate,
Hmm.
um, too desperate. There is a social shift that needs to occur. And if legislation can be a part of that, legislation can certainly be a part of that. I'm not saying that it is a bad thing to want change in the laws. But changing the laws alone will not result in meaningful change. If it did, this fight is decades old. You would think that it would have occurred by now,
Hmm.
but it truly hasn't. I don't ever want to see a case like Mr. Hogan's again.
Hmm.
Granted, I will, and I'll see plenty of them.
Hmm.
Um, but at the end of the day, if we don't address the social ills in our own communities, this will never change. Guaranteed. You can focus on the laws,
Hmm.
but focus on the social ills in our communities too, because that is something that we can all do, no matter how much or how little money we have. You could have 1 cent to your name, and this is still something you could do.
Hmm.
This is still something that I could do, and it is something that I focus on myself as well, with whatever time I have. Volunteering in this country has actually plummeted, the amount of people who volunteer. And part of that is with inflation. You've got people working two jobs that don't have a lot of time. But that's just one aspect where we see a social breakdown in what we used to do.
Definitely. And this is why I'm so glad I had you come on and talk about this and explain more of this to people. All they see is a win in a lawsuit against CPS, and it looks easy when it's really not that easy,
Absolutely.
And I'd like to have you come back on and we can even talk about more things. You know, there's so much people have to understand about CPS and what they do and how they navigate through handling parents and children.
No question. No question. And look, for me, after I got sick and tired of the child welfare bureaucracy and frustrated with the hoops that I had to jump through just to help families.
Mhm.
Uh, and I left. That's why I started CPS Protected Consulting Services. I had seen nonprofits like the Family Preservation Foundation and the Parental Rights Foundation, and they do some fantastic work,
Mhm.
children's rights as well. But unfortunately, the demand always exceeds the supply. And usually they focus on lawsuits, especially early in a case or where it's reunified. But the lucky few basically get their services, and everyone else is left hung out to dry. And I think that's a
Mhm.
terrible thing. And uh, I think that the answer isn't offering some free token services to the people that you think that you are most likely to be able to get the most out of. I think that the answer is making it affordable for everyone, and creating the institutions outside of government that essentially disrupt
Hmm.
the child welfare status quo. And through urgent assist, we are doing that.
Hmm.
Uh, we just got another review from a happy client, and it was amazing. It's
Oh,
certainly
sure.
more glowing than anything I ever got as a CPS investigator.
Mhm.
Um, you cannot underestimate CPS.
Oh,
Ideally, you should always prepare before before there's even a possibility that you think that CPS has been called. You should be doing this on day one, preparing for this, making sure that you're reducing the chances. And then from the first second of your case, everything you say or don't account for in your history, in your life, the people around you, the mandated reporters around you, the support system you have, it all matters. And therefore, that's what we do. The You get into court. By the time you get into court, the idea that even if your case comes to a positive resolution, that you're going to get it in less than 6 months
hmm.
is almost a fantasy.
Hmm.
Granted, we're working with we've been working with a subscriber in Pennsylvania, and it looks like at this point, reunification is actually going to happen in less than 6 months, which is in child welfare cases, lightning speed.
Hmm. Hmm. People don't realize that. Well, hey, how can people reach you if they have any questions?
So absolutely. Our website is cpsprotect.com. You can certainly email us, and if it's addressed directly to me, I'm happy to respond to that. You can also reach us by phone, toll free at 844-633-KIDS. We're also on Facebook, Instagram, uh, LinkedIn, X, or Twitter, or whatever they call it now,
Hmm.
uh, as well as YouTube and TikTok. Although we're relatively new to TikTok,
Hmm.
I'm not sure uh, anybody really knows we exist there yet.
I tag you. Well, hey,
Okay. Uh,
don't jump off. Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms. I'm your host, Marianne Petrie. You can find me on Spotify, YouTube, Apple, iTunes, Anchor FM, iHeartRadio, other platforms I don't know about, and feel free to buy me a coffee to keep this podcast going. Thank you so much, Jay Rosenthal from cpsprotect.com. You are a wealth of knowledge, and I totally appreciate you.
it's my pleasure. Glad to be on.
You'll be back, whether you like it or not.